Rise. The Justices of the Appellate Division, Supreme Court, First Department. Here, all persons having business with the Appellate Division. You are here, in your attendance, and shall be heard. Please be seated.
Good afternoon, everyone. Welcome to the Appellate Division, First Department. We have some 4 hours of argument time requested. So please keep that in mind when you request the time. Understand that we have your briefs, we have the record, we are fully familiar with the facts of your case, so please ask only for the time that you absolutely need. First case, People versus Shawn Jones. Six, 2, and 6. Polygenics versus Erickson.
Appellate for Juice Enterprises, we request 8 and 1.
Five and 2 and 5. You don't have a cross appeal, do you? No. Yeah. WLB Children. Submitted. Tower Insurance versus Richardson. Submitted. People versus Juan Claudio. 5, 2, and 5. Paganini versus Texter. Yep. Sorry, is this one cross appeal here? Counselor? I don't see a cross appeal here.
I'm sorry, did I withdraw that?
Yeah. I'll give 6 and 2 and 6. People versus Amazon. I'll give you 8 and 2 and 8. Ubozo versus Mueller. I'm sorry? Now, you know that there's no respondent here. Do you want to argue still? I don't see a respondent. Is there a respondent here? There's no respondent. Do you want to submit? Are you? Okay, I'll give you 2 minutes and 2 and 2. Okay? 2, 2, and a submission. People versus Derek James is submitted. Baker versus 40 East 80th Street.
The Appellate cross-respondents request 6 minutes plus 9 minutes, Your Honor. Respondent 40 East 80 cross-appellate 10 and 2, please. Respondent cross-appellate Mark Realty request 10 and 2.
Okay, I will give you I'll give you 4 and 6 for rebuttal, 5 and 2 and 5 and 2. Chen versus Ramona, Kevezel collection.
Respondent vote,
What did you ask for? Okay. 5 and 2 and 5 and 2. Polygenics versus Premier Home Health is submitted. PV Holding Corp. versus Singh is submitted. First case for argument is People versus Shawn Jones. You may begin.
Good afternoon, Your Honors. Cami Lizarraga from the Office of the Appellate Defender on behalf of Shawn Jones. The court below erred by summarily denying
The
Mr.
focus of your brief is upon this CPL 120.80 issue, but actually the affidavit which the defendant himself submitted makes the averments that the police opened drawers when they came in to execute on the arrest warrant. You seem to have abandoned that issue.
Yet, Your Honor, you are correct that his affidavit makes those two separate claims, that there was a knock and announce violation at the outset, and then also contests that the drawer was open. We do not pursue that second issue due to the rule that the affidavit that supports a search warrant cannot be challenged unless you contest the veracity of the affiant. And in this case, the police officer who conducted the search was a different officer. But the knock and announce rule, Your Honor, gets to all the evidence in the house here because Mr.
You're not going to announce, so Mr. Jones in his affidavit says that he was behind a locked bedroom door. So what's his basis of knowing whether or not there was a knock or announce?
Well, Your Honor, in his affidavit, he alleges that the police officers came into the apartment without giving notice of their authority or purpose, not only to him, but to any other occupants of the house. There were at the time two...
How is he in a position to know that since he says he was behind a locked bedroom door?
Well, he says in his affidavit, Your Honor, that he had spoken to the other occupants of the house prior to submitting the affidavit in the case.
These are hearsay assertions.
Correct, Your Honor, and in that component. However, Your Honor, what is at issue here in this case is the denial of a suppression hearing. And the allegations in this affidavit were sufficient to, if credited, support a violation of the knock and announce rule.
And counsel, in opposition to the motion that the defendant filed, what did the people submit to get around this affidavit that the defendant raised this issue?
Thank you, Your Honor. The prosecution submitted an opposition that opposed every ground raised, including this one, and acknowledged that under CPL 12080, the officers are required to knock and announce their authority and purpose. However, they simply asserted the officers did knock and announce here.
And was that conclusory? Was it supported by something?
It was conclusory. It was not supported by any factual detail, Your Honor. The officers did not, or I'm sorry, the prosecution did not say whether the officers knocked, whether
Does
they...
the record reflect whether the officers who executed the warrant were in uniform?
No, Your Honor, I don't believe it says that, but I will check that before rebuttal, Your Honor. Again, here, the respondent does not contest that the facts here were sufficient to constitute a knock and announce violation. Its sole argument is that that is not a legal basis for suppression.
As I read their brief, they do contest it, but their point is that even if there was a violation, there's still no suppression, and that's what I wanted to ask you about. As I read your briefs and the people's brief and the record, it's uncontroverted that the arrest warrant is executed. Now, the defendant says that they opened drawers. You're not contesting that at this point, and the people say it was in plain view, that they saw drugs in the bedroom. Now, the police officers don't take the evidence at that point. They leave, and many hours later, they get a search warrant and come back and execute a search warrant. Isn't there attenuation there?
No, Your Honor, because I'm sorry, let me start again. The knock and announce violation here is a but-for cause of the discovery of evidence. The purpose of the knock and announce rule is to allow the person an opportunity to open the door and
So
allow
what
the police
case
in.
says, so what case, yes, to allow a peaceful entry, but it's not directed it towards controlling the search. What case says when there's a violation of the knock and announce rule, that if the police officers see evidence and come back hours later with a search warrant, that the evidence gets suppressed? Which case do you say supports that proposition?
Well, Your Honor, Floyd supports that proposition. In Floyd,
The police, they executed on the warrant, and while they're executing on the arrest warrant, they take evidence. That's not the situation we have here, that they leave, get a warrant, and come back.
well, Your Honor, in Floyd, they saw it was because of the knock and announce violation that they saw evidence in the apartment and therefore conducted a search.
And took it on
That
the
is-
spot. And took
Well,
it on the spot.
Correct, and here, Your Honor, the
If there's a
officers would
hearing
not-
here, may I ask you, if there is a hearing here, would the judge at the hearing be able to take into consideration the credibility of the officer with regard to whether or not there was a knock, or whether there was an announcement, and also the testimony with regard to the plain view of the drugs?
Certainly, they would be able to take into account that testimony. The point is that hearing never occurred here.
I understand. So my point is that the hearing sort of stops the point of attenuation, because based on the affidavit, it's your argument that at that point, there should have been a hearing. We wouldn't even get to the attenuation part because we have to address that issue first.
Well,
Is
if
that
I
your-
could briefly respond, Your Honor.
Yes, I would,
Okay.
yeah.
If the police officers would have complied with the knock and announce rule and Mr. Jones would have had the opportunity to come to the door, they could come in to arrest him, but that's where their rights stop. They don't have the right to go into the bedroom. That was the sole basis, going into the bedroom and seeing the drugs on which the search warrant was predicated. So this was the fruit of the poisonous tree, in that viewing the packets in the bedroom stemmed from the initial illegality in which they entered the apartment without knocking and announcing, therefore barging into Mr. Jones' bedroom and seeing drugs they otherwise would not have seen. Thank you, Your Honor.
Thank you.
Good afternoon, Your Honors. May it please the court, Carl Dubel for the people. The defendant...
Counsel,
If you violated the knock and announce rule, how do you see your position withstanding, how do you see the plea being upheld?
I'm sorry, Your Honor, what?
If this is a hearing and there's a determination that the police officer who entered, whether it was Santana or someone else, if you violated the knock and announce rule, how do you see the evidence not being suppressed?
Even if we are assuming that there is a violation of the knock and announce rule, the defendant still is not entitled to suppression because the exclusionary rule doesn't apply to the application. The exclusionary rule isn't a remedy for a violation of the knock and announce rule.
I mean, I think the issue what we're really talking about here is whether or not the lower court should have summarily denied the motion without having the hearing.
Yeah.
If there is articulable facts that the defendant has submitted through his affidavit where he indicates that there was no knock, that the police officers came in and searched, and then hours later they come back with this search warrant, why is that not enough to at least have the hearing? That's all we're talking about here. We're not deciding the issue.
Yeah. So to have a hearing, the CPL requires that there is a legal basis for suppression. So even if we're assuming that all these facts are true that the defendant alleges, he still has to have a suppressionable claim. And in this case, he doesn't, because the exclusionary rule is not the proper remedy for the violation that he alleges.
Counsel, was there any independent basis for the search warrant apart from what was observed during the course of the arrest?
I don't believe so, Your Honor. The basis for the search warrant was the drugs that the police officers saw in plain view in his bedroom.
When they entered without knocking, right?
At
It
this
gets us right back to the beginning of the argument.
Yes, but even if that's true, Your Honor, the exclusionary rule doesn't apply because of this type of violation. There's no argument that,
You're saying that based upon Hudson, aren't you?
yes, exactly, Your Honor.
Well, that assumes that the state adopts the Hudson holding as under state constitutional standards. What if there was a determination, what if the state says, well, we're not following Hudson, you have more rights under the state constitution, and therefore that's not something that we're going to follow?
There's two ways to respond to that, Your Honor. First, the defense has never alleged either below or now on appeal that the state constitution gives them more rights in this context than the federal constitution. And in any event,
But they argue that Hudson doesn't apply. The courts haven't applied it in this state.
So
So isn't that the argument?
I'm sorry, Your Honor, I didn't mean to cut you off.
No, that was my question.
The defense argues Hudson doesn't apply because they think that because this is an arrest warrant case and Hudson was a search warrant case, that doesn't apply. They never say that, regardless of whether Hudson is right on the federal standard, that the state standard should apply. But regardless, I think in the exclusionary rule context, New York courts, as far as I'm aware, generally follow the federal rule. Of course, there's...
The New York courts have, in so many different instances, given more protection to their citizens. So I don't know when you
That's
say
true,
that's
Your
a
Honor.
broad statement.
So, and they create more protections as far as substantive federal rights. So sometimes the federal courts will find a violation, or they won't find a violation, and New York courts will. But as far as applying the exclusionary, this is a little bit different question because we're assuming that there's a violation under both standards, and even under that, the federal courts have said the exclusionary rule doesn't apply, and I'm not aware of cases where.
Well, let's assume that, for purposes of argument, that a violation of the knock and announce rule leads to suppression of evidence taken at the time that the arrest warrant is executed. Does that suppression requirement carry over to a subsequent search pursuant to a search warrant taking place hours later?
That's another great point, Your Honor. That's kind of the attenuation portion of our argument, where, like in Hudson, obviously the police executed the search warrant, or in their execution of the search warrant, they found the drugs immediately. Whereas here we have many intervening factors. We have the police going back to the courts. They get a signed warrant based on probable cause, and then they come back.
Yeah, but you don't get to that if you have a hearing. I'm not quite sure how the attenuation applies if you have the hearing, because as my colleague asked the question, they wouldn't even have the search warrant if they didn't violate the no-knock, presumably, because they wouldn't have been in the bedroom
I think that's
looking at drugs that they said were in plain view.
I think we're kind of speculating at that point, Your Honor, because the defendants makes the argument that...
Well, we don't have to speculate if there's a hearing. That is exactly why there should have been one. But you're saying that we should ignore that fact. That's the same thing that the dissent made a point of saying, and as I'll just say, and in Hudson, I don't know that you can show me a case where the courts have followed Hudson in this instance, but the dissent there talked about getting rid of this no-knock, getting rid of the exclusionary rule. It leads to the kind of impunity that the police have been criticized for. If they can go in and not knock, and then anything they say they find can be introduced, well, where is the prevention then? What is it to hold them back?
If I can just answer your question, Your Honor, I see I'm out of time. First, the majority considered all these arguments in Hudson, and they say that the other remedies that the defense has, as opposed to the exclusionary rule, is sufficient in this context to alleviate any of those concerns. And I believe the concurrence in Hudson made the point that there's no evidence that this is a widespread problem, which I think you're alluding to.
You know, I don't know what state they're in or what they see. In any case, thank you very much.
Thank you, Your Honor.
Thank you, Your Honor. Just briefly, the Court of Appeals has held in binding...
Hudson holds, does it not, that the violation of a failure to announce does not mandate that there be suppression of the evidence.
Hudson held that in that case, its holding was specific to that case, which involved a search warrant, which really matters because a search warrant is very different from an arrest warrant with respect to the interests implicated. The court held there in that case that the search warrant, the exclusionary rule should not apply for 2 reasons. Number one, the violation of the knock and announce rule was not the but-for cause of the discovery of evidence because the search warrant entitled them to search anyways. So even if they had complied with the knock and announce, they would have found the evidence. That's not true here with an arrest warrant where you're solely authorized to enter to arrest the person. If the person is given the opportunity.
The other prong of Hudson is that we do consider attenuation. So putting aside, let's say Hudson doesn't apply, it's not going to be accepted as the law in New York, you still have to consider the subject of attenuation.
Absolutely, Your Honor. And in that respect, Hudson is also different. Hudson held that there was a
Other than Floyd, you don't have a case which says the remedy for the violation of a knock and announce means that you must have suppression.
Well, actually, Your Honor, the Court of Appeals held as much 4 years later in Frank. There are also 2 appellate division cases that we cite where they suppressed evidence over a knock and announce violation.
True, but in all these cases, you don't have a situation where the police leave, they come back hours later with a search warrant.
But that search warrant was predicated squarely on seeing the drugs in the bedroom. And they would have had no right to go into the bedroom had they knocked and announced and given Mr.
The point of the knock and announce rule is not to bar the police from searching. The point of the knock and announce rule is to be sure that we have a peaceful entry.
But Your Honor, with an arrest warrant, the police are not entitled to search. They are only entitled to arrest, and that's what makes Hudson different, is they were entitled to search in any event, so the interest there had already been waived in the privacy of property. That's not true here with an arrest warrant where you're supposed to knock and announce, give a person an opportunity to come to the door and surrender, and the only entry is for the purposes of arrest. By not doing that here, it's resulted in a situation where the 14-year-old daughter of my client was put in handcuffs, the locked door to his bedroom where he and his wife were sleeping was banged down, and it was only then that they saw packets of drugs in the privacy of the bedroom, which goes to the very core of Fourth Amendment and constitutional privacy interests, that they saw drugs on which the search warrant was squarely based, and respondent does not refute. So without that violation, there is no discovery of evidence, and this is a legal basis for a suppression, and a suppression hearing should have been held in this case.
Thank you. Thank
you,
you
Your Honor.
both. Polygenics versus Erickson. Yes.
May it please the court.
Yes.
Defendant withdrew its only motion for summary judgment on the first cause of action prior to even oral argument. The lower court should have addressed defendant's motion for summary judgment. Had it done so, it would have had to conclude.
Counsel, there were other motions for summary judgment after that initial withdrawn motion, were there not?
Respectfully, Judge, there was one on the second cause of action, which resulted in the dismissal of the second cause of action.
Was that a summary judgment motion?
That was a summary judgment motion. Well, no, that was a motion to dismiss based on the statute of limitations. There was a 3211 motion based on statute of limitations.
So the order entered February 24th, that was a motion to dismiss?
That was a motion to dismiss, properly titled the motion to dismiss.
Properly titled, how was it titled though, counsel?
It was under 3211 based on statute of limitations.
All right.
The other motion, which was abandoned, was a motion to dismiss based
Wasn't there
on
one where
32
you didn't appear, there was no appearance movant, and so it was struck off too?
Correct. There was
That
no
happened.
appearance, and even if there
Wasn't that the first one? Wasn't that the first
That was
summary
the second
judgment?
one, I think.
second one, Judge.
The second one.
Yeah, the first one was withdrawn by stipulation. The second was a motion to dismiss based on maintaining duplicate actions, right, provided for under 3211.
So what we have here is several summary judgment motions where your client did not take advantage or did not plead their entire case, or they didn't put forth all of their positions, right? So we have these successive motions that the lower court was entitled to reject this final one.
Judge, I'm not sure I understand the question. There was never a motion for summary judgment that even reached oral argument on the first cause of action. There were just two 30-11 motions to dismiss, one which was successful.
Counsel, would you agree with the general proposition that successive motions of summary judgment are discouraged? Would you agree with that?
If it asked the court to reach the merits of that specific argument.
What's your best case for that addenda you just added?
The best case is we never argued the merits ever.
I asked you for a case. You have a case on that at all?
I don't recall at the moment. What we've cited, if you want to go to the end of this, is that the court has held that where we can avoid unnecessary litigation, we should do so. And this is exactly that case. In short, plaintiffs...
How many motions for summary judgment did you make?
One, and we withdrew it before oral argument.
So you're saying it is your position that you only made one motion?
Correct. For one motion for summary judgment, which was withdrawn before oral argument on the first cause of action.
And then the other motions were all motions to dismiss?
All motions to dismiss under 3211. One, because there was duplicate causes of action, duplicate court actions, and two, in two different courts, and two, which was granted based on the statute of limitations. Both of those are 3211s.
I don't know that we need to get there because you have got this procedural issue, but even if we did get there, isn't there an issue of fact here? I mean, the plaintiff says that he was allowed into the backyard by Souza. Souza says no one was allowed into the backyard. It's not clear whether it happened in a parking lot behind the property or it happened within the backyard. I mean, aren't there many issues of fact here anyhow?
If you read the plaintiff's affidavit, which states forth their case, all their allegations are as against the tenant. We are the landlord who gave sole control of the property by a lease, exclusive control, to the tenant. This is the landlord. If this was against the tenant, sure, this case should proceed. But the landlord had no duty because it assigned all its rights under their lease, and we put in all of the police records from the city of Cortland, which show that there was no history of crime. Thank you.
Pleases the court. My name is Alex Diaz for the Polygenics, Sacco and Phyllis.
How many motions for summary judgment did the defendants make?
It's believed that 3 summary judgments in total were done. Motion number 4, motion 3, motion 4, and motion number 6.
Why don't you pick up where opposing counsel left off with regard to, aren't there issues of fact here anyway?
Yes, indeed they are. The plaintiffs...
Counsel says that it's not, it only is with regard to the bar, not with regard to the owner.
Well, it appears from the evidence that the owner never gave a full possession of the premises and therefore was in control of the backyard area.
Are there also allegations that the owner and the bar owner may be one and the same?
That is correct, ma'am.
You can continue, sorry.
Okay. The lower court properly decided that the defendant had made successive motions for summary judgment, and it did so by filing Harris v. Gerber. And here, like in Harris v. Gerber, the defendant's motion was defective and failed to offer any newly discovered evidence to demonstrate sufficient cause. Because the motion was previously decided, motion number 6, when decided, the court's decision stated defendant's motions, in plural, for summary judgment are denied. And contrary to defendant's counsel assertions, successive motions for summary judgment are not allowed. So based on this decision, it is plaintiff's contention that the court did, in fact, consider the merits of the case. And so therefore, it should be denied, and therefore it's moot to even go forward with this appeal any further. Lastly, should the court consider the defendant's summary judgment motion, then the defendant actually had a duty because he caused and created the situation. He allowed permission to use the backyard. Furthermore, absent, he had a reasonable duty to keep it safe, to make sure that at least warn of any problems. they ejected a belligerent individual, Mr. Erickson in this case, who later ended up assaulting our client and causing him a fracture to the face. Next, the defendant also should have had safety precautions. There were over 300 patrons in the bar, and he gave permission to go outside and use the backyard and not have any proper bouncers in the area or anything of that nature. Additionally, the defendant mentioned that they had just learned of new information. However, their prior motions, their affidavits showed that they did know that the incident did occur in the back and not inside the premises. So they had no new information, no new evidence, no new law that changed anything. So therefore, their case should be denied. The summary judgment should be denied.
Thank you.
Thank you, ma'am.
The landlord and the tenant are two separate corporations, and the owners are not identical. The landlord is not licensed by the state of New York.
But there are allegations with regard to that. There are questions of fact that have been brought up that would have to be litigated further. That question went to whether there were questions of fact.
We disagree that they're questions of fact. The lease is unquestionable. The lease gave exclusive right to control the premises, licensed by the state of New York. The landlord has no legal authority to control the premises, and the exclusive obligation or ability to do that was with the tenant, never the landlord. All of their claims are as against the tenant, not the landlord. These were the tenant's employees.
Does it matter that there were prior incidents of violence occurring on those premises that the landlord would have had notice of?
If that was true, that would be relevant, except we submitted undisputable proof from the city of Cortland showing no criminal history of any criminal conduct whatsoever in back of the building where this allegation took place. So
Didn't the police indicate that weren't there police records later that showed that there were 2 incidents in the last 5 years when you said there were none?
There were none in back of the bar whatsoever. There were some well in front of the bar across the street, but there were absolutely none in back of the bar where this occurred. There are numerous cases we've submitted which show that you have to look to the area where the assaults occurred. So the landlord never acquired any duty more than their minimal duty to provide a safe place. All of their allegations are with regard to the tenant and the tenant's fault. Why they didn't sue the tenant, not the landlord's fault. Thank you, Judge.
Thank you. Thank you both. People versus Juan Claudio.
Good afternoon, Your Honors. I'm Catherine Martone on behalf of Mr. Claudio. The trial court here erred in denying the defense request for a lesser included offense instruction. Under the applicable 2-part test, a trial court is required to submit a lesser where first it's a valid lesser, and second, a reasonable...
Counsel, was this a valid lesser? Was there any view of this, this evidence that would suggest that there was some reason other than wanting to burglarize the place that the defendant
Yes.
gave?
Yes, there was, Your Honor. Under the second prong of the a test for submitting the lesser, there was a reasonable view of the evidence viewed in the light most favorable to the defense, based upon the fact that the space where Mr. Claudio was arrested was a roof garden, which is a place where people just,
But it wasn't his roof garden, and he had no business in the building, and he was there standing, he was not standing gardening, he was hiding, and he was found right alongside of the things that were taken from the apartment.
That's all true. That's all true, Your Honor.
Okay.
The fact that he was in the place where he did not belong, that was a roof garden, was the basis upon which the jury could reasonably find that he was in fact guilty of trespass. The fact that
Even though he was wearing clothes and that were identifiable with the burglar.
Well, that's the point, that's the most important point here, Your Honor, which supports our argument that there is a reasonable view that while trespassing, he was not guilty.
Even though there's stolen, there are stolen items next to him?
Yes, Your Honor, because he did not match the description of the only witness who observed the burglar enter the apartment. That witness, Mr. Rizzuto, described
But he
the burglar.
admits being in the building. So what you're suggesting is that there's a case of mistaken identity here.
That's right. We're saying that he did not commit the burglary, although it is true that he was guilty of being in the building, which
And it's also
constitutes
true
the
that when
trespass.
he's found with stolen merchandise.
He wasn't found with it, Your Honor, and as
Close
counsel argued, there's a reasonable view of that evidence that also indicates he's not guilty of the burglary because the items were found out in the open right at his feet. And as counsel argued, if you're the person who stole those things, are you going to discard them at your own feet, or are you going to throw them away from you?
And you know,
That all depends on whether he's running away and thinking he can get away, and he doesn't quite get away because he's arrested before he does.
Your Honor, then on that view of it, the property would have been on his person.
We don't know where it would have been. We only know what we have, which is that he's standing right beside the property that was in the building that was stolen from the very apartment that an eyewitness, saw someone dressed very much like him. He wasn't all in brown, but he was in all dark clothing with the white sneakers. The same, so that's...
Your Honor, this is very important here, that the description the only witness to the burglary gave was a distinctive description. So the view of the case that credits his distinctive description of a person dressed all in dark brown and credits the prosecution's other witness who described someone dressed in gray and black is the defense, it supports the submission of the lesser because it credits both witnesses, because both witnesses provided different descriptions. Therefore, both witnesses support the defense view that there were two people present, that there was more than one person at the scene.
But the officer that saw him on the fire escape and then saw him climb up to the rooftop is the officer that later came up to the rooftop when he was arrested and noticed that he was dressed exactly as he saw, wearing gray and black.
So that officer, Your Honor, did not see anyone go into or come out of the complaining witness's apartment.
But saw him on the fire escape and then saw him climb to the rooftop.
Saw someone on the fire escape, that's right. So the only person that was seen going into the complaining witness's apartment is dressed all in dark brown.
Okay, so then,
according to the other witness.
so then let's using logic, someone sees a person dressed exactly the way that the defendant is dressed.
Yes.
On the fire escape.
Yes.
Climb up to the rooftop. Correct? Then your client is arrested, the defendant is arrested.
Yes.
Wearing the same type of clothing.
Yes.
The officer that sees him on the fire escape goes up to the rooftop and says, dressed exactly the way I saw him on the fire escape.
Yes.
And on top of that, they recover the property, which is the watch and
yes,
the coins.
Yes.
And then the dwellers of the apartment that was broken into say, we're missing a watch, we're missing coins, and our apartment was ransacked.
Yes.
So now, what is the logical conclusion?
So, Your Honor, the logical conclusion is that there were, in fact, two people there. Because your, that view that you just set forth completely excludes the prosecution's own evidence about the distinctive description and the fact that the only eyewitness to the burglary did not identify Mr. Claudio in a show-up only a couple of minutes after the incident.
How does your client explain that he was only there trespassing and not, based on all the totality of all the evidence that was presented at trial, and not that he was the burglar?
He explains
Because he's
that
got the property, and he's dressed just like the person that they saw on the fire escape of the apartment that was burglarized.
Yes, so, Your Honor, the only facts supporting that view of the evidence that the court, and this is just to get the lesser, right? So that the lesser should have been submitted for the jury to consider. The facts that I'm relying on, which are in the prosecution's case, are that he didn't match the description and the eyewitness did not identify him in a show-up or his clothing.
Thank you.
And
Just finish up that thought. We'll,
no, I think
Okay.
I've expressed it, Your Honor.
okay, thank you.
Yeah.
Good afternoon again, Your Honors. Carl Dugal for the
You have
people.
double duty today.
Yes. As Your Honors had alluded to, there's no reasonable view of the evidence that defendant was in the building.
Well, why couldn't he just be trespassing? He's not exactly the same person. He's not exactly dressed exactly the same way as the eyewitness who saw him climb up and go into the apartment says he was. Is it rational or reasonable?
Not so, Your Honor, because there's just so much other evidence connecting him to being the person that went into the building. And Rizzuto, he was viewing him from a little distance away. He said he was wearing dark clothing. He thought it was dark brown, but at the end, the defendant was wearing a dark gray, which, you know, from a distance, it's understandable how those two things could be confused. But what's also important here is the timing of all of this. Rizzuto saw him going into the apartment, and within 10 or 15 minutes, the police were already on the scene, and they saw him on the fire escape outside the exact same window that Rizzuto saw him go into. And then when the police go up to the roof, they see him standing next to all of the two items that were stolen from the apartment, and there's no one else on the roof. As the police went up through the building, they said they saw no one else in the building. And also, I would push back just a little bit on defendant's argument about why Rizzuto didn't ID him in a show-up. As I said, he saw him from a distance, and also Rizzuto said he couldn't ID him, not because he was wearing different clothes, but because the person he saw go into the building was wearing a hat and he couldn't see his face. So that's why he couldn't positively identify him. If there's no further questions, I'll just ask that you affirm.
Thank you.
Thank you.
I would just be very brief and say that there's no basis on this record to not consider Mr. Rizzuto's distinctive description of the burglar, because it was distinctive, which confirms that he actually saw it, and he gave it consistently from his very first report to 911. He gave that distinctive description again to the responding police officers, and he testified to it again at trial without ever showing any hesitancy or equivocation about it. The only view of the evidence that takes into account all of the prosecution's evidence, and there's no basis for simply rejecting Mr. Rizzuto's testimony, is the one that there were, in fact, two people present.
One question. Rizzuto said he saw the perpetrator put gloves on. Did they recover any gloves from the defendant?
Yes, they did recover gloves, but Your Honor, it was November, you know? So these facts, you know, his proximity to the stolen property, that's a permissive inference that the jury could draw, you know, that he was aware that it was stolen property from his proximity to it. That's a permissive inference as opposed to the unequivocal testimony of the eyewitness to the burglary. I mean, if this jury was going to discount anyone's testimony, it would be the police officers, which was incredible, I would say, as a matter of pure common sense, that as she's responding to a burglary in progress, she claimed that she stopped to write down in her memo book in that moment the description of the man she saw on the fire escape. She was holding a radio in her hand, and instead of transmitting the description so that the other officers would have the benefit of her information, she claimed she stopped and she wrote the description in her memo book at that time, and she wrote it in her memo book while she was holding her radio, her memo book and her radio in one hand and writing with the other.
Thank you.
So,
I think we understand the point. Thank you both. Paganini versus Texter.
Good afternoon, Your Honors. May it please the court, my name is Stephen Sperber. I'm here for the appellant. The decision of the court below, which found that the personal guarantees did not apply, is contrary to the facts.
So, counsel, the guarantees talk about the renewal, the possibility that if there's a renewal lease, they would apply. But where in the actual leases, the subsequent leases, does it say anything about there being a renewal? And I'm not talking about what was in the complaint. I'm talking about the leases themselves.
Your Honor, I concede that it doesn't say that, but I also would argue that that is exalting form over substance. If you look at the three leases...
Isn't that the most important substance, the lease, the
Not
documents?
at all, Judge, because the lesson that we learn, if you look at the language, the guarantee applies to all renewals.
Well, counsel, the addition of the termination provision in the last lease, why doesn't that turn it into a new lease and not a renewal? Because it's added this new language.
Judge, the lesson that we learned from the cases that talk about a new lease not applying the guarantee all uniformly hold that there's additional obligations. The lead case is the case where the lease expired in May, and in June, the landlord sent a renewal lease, and in that renewal lease added, that's the Loho against Batista, added additional obligations in the form of real estate taxes and a substantial build-out. A review, just a mere cursory review at bar, shows that all three leases were same parties, same term, same rent. It was the exact same rent. The rent stayed at $2,900.
But there was this new requirement of the early termination, and what would happen if they terminated and their obligations under that?
That's not an obligation, no. That's a benefit. That gave the tenant the right. It gave them something that they didn't have in the prior leases, but it didn't impose any additional obligations. And to take that view, Judge, I most respectfully submit, would to be render the language of the original guarantee utterly meaningless. And I point out, Your Honor, that this is a 3211 motion, and in a 3211 motion, all facts that could possibly construe to my favor should be construed in my favor. And the court below failed to even consider that at the very pleadings, the other side pled that they entered into renewal leases. That was found at record page 12. So they come to the court and they say, we signed 2 renewal leases. Not we signed 2 leases. This is not after trial. This is on a 32.
But the court can view the law. I mean, the court has to consider the law, and the fact that they say that in the complaint doesn't render it automatically a lease that the court can't look at anew. I mean, the court was making that determination based on what the lease said. But what about the law that governs guarantees? Aren't guarantees supposed to be viewed narrowly?
Yes.
So
and the reason that that doesn't apply here, again, is because there is no new obligations. I would say that if the rent went up $100 a month, that wouldn't be enough to negate the guarantee. But here, it didn't go up at all. It was the exact same thing. The landlord would have never entered this lease but for the parent's guarantee. And when the leases were renewed, the fact that instead of using 1 page, he used 2 pages, and instead of saying renewal on it, he'd made it a new lease, same party, same price, same everything. And so, again, we're looking at form over substance, because if you look at the substance, it's just a renewal of the exact same lease. Thank you.
Thank you.
Good afternoon, Your Honors. May it please the court, Bikram Singh for the third-party defendant respondent. The lower court was correct in granting guarantor's pre-answer motion to dismiss pursuant to 3211A17. It was based on documentary evidence, and documentary evidence were.
So counsel, okay, wait, we know the documentary evidence of these leases, but counsel is indicating that the leases don't look anything different.
The counsel relies on the Loho LLC case. Yes, indeed, it is in the subsequent lease, the rent was different. And that's one of the reasons that the court used to say that that was that was a separate full-form lease and not a renewal lease. But that's one of the factors that the court used. That was not the only factor that the court used. The court also said those were brand new full-form leases. The court also stated that the guarantees are to be strictly construed, and the lower court, the Supreme Court, relied on that fact and stated that the guarantees executed by the third-party defendant respondents contain no language indicating that they shall survive the expiration date of the 2019 lease. It also contained no language indicating that they would have any application to a subsequent lease the parties might enter into.
Counsel, is there an issue of fact concerning the meeting of the minds between the parties? Because your clients did put in affidavits describing these as renewal leases in the J51 causes of action, correct?
Your Honor, there was never a consent by my clients to agree to any kind of guarantees for subsequent second or the third lease. There was the first lease, indeed.
But the guarantees did say they would apply to renewal leases, correct?
I'm sorry?
Did the guarantees say that they would apply to renewal leases?
Yes, indeed, but they were not. The court should not look at beyond the four corners of the document itself. They were full, fresh, brand new leases. Just because the guarantee stated that they would apply to renewal leases, but these were not renewal leases. If they wanted to issue renewal leases, they could have done that, voluntarily offer renewal leases, but that was not the case. That's the decision and choice that they made. And counsel, in his brief, also relies on a pre-litigation letter that was sent by my firm where we misdescribed the subsequent leases as renewal leases. But lower court was correct in holding that that is of no significance. Just because a party's mischaracterization by a party does not necessarily, of a fact does not necessarily change the legal analysis as a matter of law. For instance, if I call my apartment a rent-stabilized apartment, doesn't mean that it is a rent-stabilized apartment. The determination would have to be made based on operation of the law. So that argument should be disregarded. Based on the foregoing, Your Honors, I respectfully request that the appeal should be denied and the lower court should be affirmed.
Thank you.
Briefly, four things.
I mean, I don't think we get there because there isn't an ambiguity warranting it. But I mean, what you have is this new early termination provision, right?
Yes.
That was a new provision. I mean, do you think it's a reasonable way to look at this that the landlord agreed to an early termination of the lease with the idea the tenant will go and I'll go after the guarantors?
No.
I mean,
not in the least. The tenants are the ones that requested it. It was during the COVID period. Four things,
but the
Your Honor.
landlord agreed to it.
The landlord did agree to it. That's right.
Which
And
is
they
a new
didn't follow
term.
it. And that's why we're here.
It's a new term that wasn't in the original lease.
But again, see, I'm reading from the Batista case, which is the lead case. The increased rent would have substantially and impermissibly changed the guarantor's obligations under the original lease. That's why it didn't obligate the guarantor. That's point one. Point two, they verified, forget about the letter, they swore under oath that they signed a renewal lease. Point three, what does the language that says this guarantee applies to any extensions of time or renewals? The guarantee will bind me even if I'm not a party to these changes. What could that possibly mean? This is a 3211 motion. And fourthly, Judge, exactly what my adversary said. They could have used the form, but instead they used the lease. Form over substance is what the decision of the court below is based on, and I respectfully submit it should be reversed. Thank you.
Thank you both. Justice Moulton is recused from the next case. People of State of New York versus Amazon.com.
Good afternoon, Your Honors. May it please the Court. Jason Schwartz on behalf of Appellant Amazon. I'd like to begin, Your Honors, by addressing the National Labor Relations Act preemption issue that applies to 4 of the 5 causes of action. At the outset of this matter, when Mr. Smalls was terminated, the Attorney General called on the National Labor Relations Board to investigate. She was right. Under the Supreme Court's controlling decisions in Garman, Brown, and Jones, the causes of action for retaliation are preempted by federal law. That is because they are the same in a, quote, fundamental respect under Jones, a controlling case that is not cited by the Attorney General anywhere in her briefs. We know this for 2 reasons, that the acts were protected under the National Labor Relations Act. We know this for a certainty for 2 reasons. Number 1, because pending before the National Labor Relations Board is an identical proceeding brought on behalf of Mr. Bryson. He is alleged to have done the exact same things, to have interrupted the same management meetings on the same days, and to have participated in protest on the same date. In addition, Mr. Smalls and Mr. Palmer, who submitted evidence in that case, are alleged to have been retaliated against, and that is evidence that is used supposedly to prove the retaliation against Bryson. So the same factual issues of causation, just like Jones, are at issue before the National Labor Relations Board. Second, and equally as important, if you took Mr. Bryson's charge at the National Labor Relations Board and you struck his name and inserted Mr. Smalls or Mr. Palmer, they would have the same cause of action, meaning...
Is there a view of this that Bryson's, the retaliation involves Bryson's protesting, whereas Smalls and Palmer were engaged in whistleblowing?
Your Honor, the underlying facts, and we look at the conduct, not the labels, under the Supreme Court's decision in Lockridge and Gould, the underlying facts are exactly the same. The words are almost verbatim in the Attorney General's complaint and in the charge before the National Labor Relations Board, that they raised concerns about workplace safety by disrupting management meetings together, Smalls, Palmer, and Bryson, collective activity, and by holding a protest in the parking lot.
Counsel, is there some view that their actions were so deeply rooted in local feelings that we could find a Garmin exception here?
I'm glad you asked that, Your Honor. There are 3 reasons why the local interest exception does not apply. Number 1, under Garmin and Brown, if it is either clear or may fairly be assumed that the activities are protected under federal law, here we know they are because the National Labor Relations Board has taken cognizance over the same activities, then preemption is a matter of substantive right, not subject to the local interest exception. Number 2, whistleblowing is not a local interest. It did not exist in the 1930s at the time of the National Labor Relations Act, and I would direct the court respectfully to the Andrew Sekas decision, a well-reasoned district court decision that explains and cites many, many cases that whistleblowing is actually within the heartland of the National Labor Relations Act. It's not a unique local police interest, for example.
If we were to allow concurrent jurisdiction, wouldn't there be a risk of inconsistent decisions?
That's exactly right, Your Honor, and that's the 3rd reason why the local interest exception does not apply. Even if it were a deeply rooted interest, if there is, quote, a risk of conflicting rulings under the Supreme Court's controlling decision in Jones, then the local interest exception doesn't apply and preemption must control. The state must yield to the NLRB. Here, of course, there's a risk of conflicting decisions because the NLRB judge has been asked to decide whether Palmer and Smalls were retaliated against for their safety complaints at the same events as probative evidence supporting Mr. Bryson's case. If that judge rules one way, and Justice Bannon rules another, of course there's a risk of that conflicting possibility, and under Jones, that controls and means there is no local interest exception that could possibly apply. If I might, Your Honor, just one last point on the whistleblowing, then I'd like to turn to Section 200. Labor Law Section 740, the Attorney General has added words to it in the complaint and/or regulatory guidance. That's nowhere to be found in the statute. That's not protected activity. Again, the Attorney General correctly argued that in Officer Quirk's case, citing the only decision I'm aware of to examine this, the HC2 decision from the Southern District, which found that pointing to regulatory guidance is not sufficient to state a cause of action under 740. Let me move to the Section 200, and I know Your Honors are all experienced with Section 200. It is, as the Attorney General describes it, a statutory tort claim, meaning duty, breach, injury, causation. Here, the Attorney General is trying, again, to create law that does not exist. There is no case that we have identified and no case that the Attorney General has cited where a court has ever used Section 200 or even 6312 overlaid on top of it to grant prospective injunctive relief to create a new safety regime. That's literally unheard of, not authorized by the law. Second, Section 200 does not cover ubiquitous biological threats. It covers unsafe, hazardous conditions at a physical workplace. There's no court that's held otherwise, and in fact, there's a separate statute, Labor Law 297, that deals with biological threats from infectious disease. Again, the Attorney General doesn't even address that in her brief. Moreover, Section 200 requires a specific process set forth by the legislature to get injunctive relief. The Labor Commissioner inspects, the Labor Commissioner provides notice, the employer disobeys, and then and only then is the Attorney General authorized to seek injunctive relief. The Section 200 claim also the Attorney General has cited as support the People versus Pym case from the Court of Appeals. I would suggest, Your Honor, that that case directly controls here and tells you exactly what I'm arguing, which is that if there were some retrospective look at something that was a crime, like an assault, in Pym, they had a secret underground lab, literally, where they were smashing thermometers, getting the mercury out, and that was assaulting the workers. That was a crime recognizable at local law. However, the Court of Appeals also said, we're not in the business of setting forth prospective relief to create a safety regime. That's the business of the Occupational Safety and Health Administration. The Attorney General, again, in her own words, she cited the 29 CFR, the federal regulatory provisions that applied in her predetermination in this case. Those regulations all apply. They're of preemptive force under GAID. The savings clause does not apply because that's only for tort causes of action for injury. That was specifically addressed in GAID, which prohibited a forward-looking prospective regulatory scheme under state law. The Attorney General says that was not a holding. That was a holding of GAID. And then finally, where we have this non-binding guidance, didn't exist in March, only came in May, is now outdated, has been withdrawn, the emergency has passed, the governor has actually declared under the HERO Act that this is no longer the same state. It's evolving day by day. We should defer to the expertise of the Occupational Safety and Health Administration, as Judge Kogan did in the Palmer case. This is not a matter where a court should create a new remedy not authorized at law in order to ad hoc create a safety regime.
Thank you. Counsel,
Thank you, Your Honors.
Thank you. I'm going to ask that you tighten up your mask because it's supposed to cover your nose and mouth. It's not fair to everybody else who's sitting here uncomfortably, I imagine. So just tighten it up so that it doesn't keep falling.
Oh, yes, Your Honor, will do.
Before
I
you come back
apologize.
up. Thank you.
May it please the Court, Esther Mardukayeva for the Attorney General. I'll begin with
If
the...
you could pick up with where your adversary left off, the state has withdrawn its Section 200 guidance that's what your claim sought to enforce. How can the Section 200 claim survive without reference to that guidance?
Well, Your Honor, I think there are two separate parts of your question. We are here on a motion to dismiss, which means we're still at the liability stage of this proceeding. So at the liability stage, you would determine whether there has been a violation, and then there would be, if there is such a finding, there would be a remedial stage where you would determine what kind of relief prospective relief is necessary to address that particular violation. I think your question goes to what kind of remedies may be appropriate.
Doesn't it go to whether this claim has become moot?
Well, Your Honor, there is a pending motion about mootness in front of
Below.
Supreme Court that is not before this court, so I don't think that is part of this court's consideration. But what I would say is that the
Is
claim...
there a reason why this court couldn't consider that in light of the fact that the state has withdrawn this guidance?
Well, Your Honor, our claim was not based on that particular guidance alone. Our claim referenced several forms of guidance from different sources, as well as basic principles of reasonableness. And I can get to this if we have time on the Section 200 claim. The reason we're not seeking to enforce any guidance in particular is that we're only referencing that guidance as a measure of what is reasonable. That is a common term that applies in many different statutes. The withdrawal of one particular form of guidance does not by itself disprove reasonableness. I'll turn to the NLRA preemption issue. The Court of Appeals correctly found in the Helmsley-Spear case that the field of labor relations involves activity and regulation by both federal authorities and state authorities. The federal government is focused on protecting collective bargaining and labor organization, while state governments retain their traditional authority over matters of workplace health and safety. And that is what the garment preemption doctrine seeks to police. What it seeks to do is ensure that the federal government has uniform regulation over issues pertaining to concerted activity and collective bargaining and labor organization, while states retain their traditional authority here. The retaliation claims in the Attorney General's complaint have nothing to do with collective bargaining. They have nothing to do with concerted activity. There are many different types of anti-retaliation provisions in New York state law. Many of them pertain to the workplace context. It cannot be that all of those provisions and protections are wiped off the books if more than one employee happens to complain or make a report of a state law violation at a given time. In order to make a ruling for the Attorney General on these anti-retaliation claims, the state court has to make no findings or conclusions with respect to the question of concerted activity at all. The Bryson proceeding has nothing to do with this case, nothing to do with the particular claims in this case.
Doesn't it involve, as my colleague already asked the question, I think, that it involves the same, essentially the same allegations of retaliation?
Well, Your Honor, the NLRB has only sought relief on behalf of Mr. Bryson. The NLRB has not sought any relief with respect to Mr. Palmer or Mr. Smalls, and can no longer do so because the NLRB does not have plenary enforcement authority. It must act only upon the filing of charges, and the statute of limitations has expired with respect to potential charges that could be brought on behalf of Mr. Palmer or Mr. Smalls.
To the NLRB, and it wasn't because the statute of limitations has elapsed. Does that mean something which should have been there now becomes a matter for state court?
No, Your Honor, because there is no reason to find that this claim must have been brought before the NLRB. This claim is about retaliation against an employee who makes complaints about violations of New York state law. Though that activity is protected by state law. If there was only one employee who made a complaint or a
hasn't the
report of state law,
NLRB been pursuing a similar retaliation claim against the defendant?
the NLRB has been pursuing an action against Amazon with respect to Mr. Bryson.
In Bryson, I mean, it's the same claim basically, is it not?
It is not the same claim, Your Honor. The NLRB claim by necessity is about retaliation for Mr. Bryson's participation in concerted activity. Our retaliation claims have nothing to do with concerted activity. They are focused on Mr. Palmer and Mr. Smalls' reporting of state law violations, which has nothing to do with whether they did so alone or whether they did so in concert with other people. And even if this conduct arguably constitutes concerted activity, the local interest exception squarely applies. We are not seeking to vindicate a whistleblowing interest. Our anti-retaliation laws serve the same underlying purposes as the substantive labor laws. They advance workplace health and safety because they help deter potential violations, ensure that employees can report violations of the law without fear of retribution, and make sure that the state or other authorities can vindicate and correct workplace health and safety violations. None of those things have to do with whistleblowing for the sake of whistleblowing.
You are right. You know, the underlying instances at their core have to do with state-protected violations, the workplace safety. But, you know, going into the way it was done, it wasn't just merely, I have a complaint. You know, the protest on the one hand, and then the going into boardrooms or whatever it is on the other hand, are very, that is what the NLRB is. It's that kind of action that they are, is why the state is preempted in this case. We're not really talking about the workplace safety violation.
Well, Your Honor, the NLRB is not talking about the workplace safety violation. We are. Our claim has nothing to do with whether these individuals made reports in the form of a protest, made them independently, made them in a meeting. That fact is simply irrelevant to the underlying elements of our claim. Our claim turns on the reporting of the workplace safety violation. And that is why it is distinct, and that is why the local interest exception would apply, even if the NLRA arguably covered some of this conduct. If I may briefly address the Section 200 claim, I see that I am almost
I thought we started with that, but yes.
I'd like to return to it and just make a few points on preemption and primary jurisdiction, if I may. The OSH Act preempts only state actions pertaining to workplace safety issues for which there is an existing OSHA standard. There are no existing OSHA standards that are applicable to the workplace safety issues here. The 2 ETSs that OSHA issued are no longer in effect and did not cover this conduct even when they were in effect.
Are we dealing with a biological hazard here, and does Labor Law 200 cover biological hazards?
Your Honor, Labor Law 200 very broadly requires an employer to provide reasonable and adequate protection to the lives, health, and safety of all persons employed therein. That language does not make a distinction between the origin of the hazard, the type of the hazard. If there is a workplace safety issue that arises because there is an airborne virus, and I don't think anyone disputes that there are workplace safety issues that are related to the transmission of COVID-19, then the plain text of Section 200 does apply. And the last thing I would note, if I may, is that OSHA has already decided to defer any of its own inspections of JFK 8 in consideration of the Attorney General's enforcement action.
Just before you go, I want to ask you about something off what you've been talking about. I noticed that there was a New York City Sheriff's Office investigation of the safety practices of the defendant, and they determined that their practices were satisfactory. How did that come about?
Well, Your Honor, I would say that that fact is outside of the complaint, and I don't think it's possible to take judicial notice of it. I would say Amazon inflates the nature of what happened there.
I saw it in the briefs.
There was an individual from the sheriff's office who went to the facility, who had some email communications with managers at the facility, and what Amazon points to as this conclusion of a New York sheriff's investigation is a paragraph in an email that was sent from one particular inspector to a manager at the facility. Even if that could be considered on a 3211 motion when it's not part of the complaint, I don't actually think that fact has any bearing to whether we've stated a claim. At most, Amazon may be able to point to it on the merits. Thank you, Your Honor.
Thank you.
Thank you, Your Honor. May it please the court, just a few points. Number one, the complaint is clearly based on now withdrawn guidance. There are 43 references in the complaint to that non-binding guidance. Number two, regardless of the semantics, the underlying conduct is exactly the same. The interruptions of the manager meetings, the protest in the parking lot, under Lockridge and Gould, it is the conduct that matters, not the semantic description of it. And even if it is arguably within the jurisdiction of the National Labor Relations Board, there is a presumption of preemption under Brown, Garmin, and this court has recognized that in the Juju case. Moreover, the issue is not the protest. Everybody agrees what they did. It's the causation. Were they retaliated against for engaging in that activity?
But your adversary makes the point that as to Palmer and Smalls, the statute of limitations has run on their claims as to the national NLRB?
It doesn't matter, Your Honor. It's a matter of substantive right. That is the agency with the sole and exclusive jurisdiction. And by the way, that agency may very well, in the Bryson proceeding, reach a conflicting decision about whether Palmer and Smalls themselves were retaliated against, because the board's general counsel has argued that as supporting evidence for Bryson's case. But even if it's never brought to the board, board preemption does not yield just because the statute of limitations is expired. As to OSHA preemption, there are specific standards: 1910-22 on sanitation, 141 on sanitation, 132 on personal protective equipment, 134 on respiratory protection, 1404 on record keeping. They don't have to have a separate standard for the flu, mumps, measles, COVID, etc. These standards apply. OSHA has enforced them and issued hundreds of citations related to COVID. Finally, with respect to the sheriff's inspection, the court can take judicial notice. What's important here is that Section 200, in order to get injunctive relief, requires an on-site inspection by the Commissioner of Labor, followed by notice, followed by an Attorney General proceeding. Here, the only person who ever came on site was a sheriff's lieutenant and a squad of armed deputies for multiple visits, one unannounced. They said they went above and beyond compliance requirements, and any complaints to the contrary were baseless. Thank you. Appreciate the court's time.
Thank you. Thank you both. Ubozo versus Mueller.
Good afternoon, Your Honors. May it please the Court, Lauren Mazzara for Appellant Bruce Mark Mueller. Defendant Mueller submitted filed a motion for summary judgment on the grounds that plaintiff was precluded through a self-executing order of preclusion dated August 9, 2019, from presenting any evidence as to her injuries if she failed to provide a bill of particulars and authorizations by September 9, 2019. Plaintiff failed to provide the requested bill of particulars and authorizations, thereby the self-executing order of preclusion became absolute. Despite this fact, our motion for summary judgment.
So you're telling us that you want to ensure that the self-executing order is upheld?
Correct, Your Honor. And our unopposed motion for summary judgment was denied with leave to renew by Justice Barbato, and then recently on February 17, 2022, he reversed his decision and granted our motion to re-argue.
Thank you.
Thank you.
Is your argument different than counsel's?
No, Your Honor. I would just like to point out to the court, though, that we similarly, and I apologize, I'm Sarah Zilkowski for the defendant, Trevor John. We similarly move for re-argument of the denial of a motion for summary judgment, and unfortunately, it was assigned to a different judge, and it was decided by a different judge and denied. So we do believe that the proper outcome is what Judge Barbato did for our co-defendant Mueller. They granted re-argument, and upon re-argument granted summary judgment to Mueller, and we would ask that this court similarly find that defendant John's motion for summary judgment should have been granted by the court.
The order in front of us on appeal is the one of August 27, 2020.
Correct, Your Honor.
Subsequent orders are not in front of us.
Well, that we can appeal the subsequent denial of our motion to re-argue. We just wanted to bring it judicial notice to the court's attention that a different judge decided, Judge Perez decided our motion to re-argue, and Judge Barbato is back on the bench and decided co-defendant's motion to re-argue.
Thank you.
Thank you, Your Honors.
Baker versus 40 East 80th Apartments.
a 5,000-page report.
It's okay with us.
I know that
Yeah.
Here he is.
He went downstairs.
May it please the court, my name is John Brickman of McLaughlin and Stern, and I appear for the Bakers, who are the plaintiffs, appellants, cross-respondents. We don't quarrel with the substance of the verdict below, but we urge that the judgment as entered needs modification in several respects. First, interest should have been added to the rent abatement award, and this follows for several reasons that are essentially independent. First, it represents the Baker's entitlement to the return of money actually spent as maintenance was paid from month to month and year to year, which the trial court properly ruled must be returned to the Bakers. They were out of pocket. The corporation had the use and benefit of the funds over the years. Its return should be
Also, was there some delay at some points during the course of this very lengthy litigation in the Bakers paying their maintenance? And therefore, is there an equitable argument that interest should not be due because there was delay on behalf of your clients as well?
Your Honor, that would be a matter for a late fee, perhaps. But in terms of interest overall, the requirement, the obligation to pay rent is a pure matter of contract, the lease. And 5001 really is absolute, and the only circumstance in which there can be an equitable, not toll, but an equitable justification to deny interest is when, for example, a defendant tenders payment, and a person entitled to receive the payment arbitrarily refuses. That's not the case here. No matter how long it took, the corporation had the use and benefit of the money. The fact that the interest rate that the legislature in its wisdom has thought fit to set may be higher than what the interest rates in the market have been lately.
Going back to the trial, I mean, the mold claim had been dismissed.
Yes.
Did it make its way in through the back door via turning it into a claim for water damage?
I'm sorry, Your Honor, you said...
Did it make its way in through the back door by turning it into a claim for water damage and then allowing proof of mold damages?
Well, it was always a claim for mold and water damage, Your Honor. From the beginning, moisture was as much an element.
But then evidence about mold was allowed in under a water claim, right?
Right, and there was nothing was...
Is that consistent with the ruling to dismiss the mold claim?
Well, there was, a judge made it very clear quite quickly that while he was not going to award damages for mold, he was not precluding himself from awarding damages for losses caused by water or moisture. And he was adamant in that, and quite quickly after he issued his ruling on the mold claim. So if I want to come back, if I can, to the interest, there's an illogic there as well, because while the court awarded interest for the extent of the Baker's alternative living expenses that exceeded the rent, it awarded no interest for the rent itself.
Thank you. You have 6 minutes of rebuttal, so I think you
say.
asked for the majority of time in rebuttal,
Yes.
so you got it. Okay,
Thank you.
Thank you.
Good afternoon. My name is David Schultz with the firm of Barry, McTurnan and Moore. We represent 40 East 80 Apartment Corporation. We'd just like to start with the mold claim. At trial, Justice Nervo dismissed all causes of action or claims for damages as the result of the presence of mold, fungus, and moisture. Contrary to what Mr. Brickman said, moisture did not remain in this case.
So are you saying water as distinct from moisture?
Correct.
Water is in the case. Water damage
I was about to say, after the judge dismissed the mold and moisture claims, all that was left was a claim for water intrusion and water damage. The judge, in his written decision, said that there was no evidence that mold rendered the apartment dangerous, unhealthy.
Okay, but that was only with regard to the that was only with regard to the mold and whether there was damage from mold, not whether there was damage from water.
Correct.
Usually, mold doesn't happen where there's no water.
Possibly. However, the judge didn't just dismiss, he dismissed the claims for damages as the result of mold.
Okay.
So if mold caused damage, therefore, no recovery can be made.
Okay, but water causes damage too.
Correct. If water damaged property or was the result for vacator of the premises, that would be permissible. The only evidence of water infiltration is on September 8th and September 28th of 2004. As far as all of the other, 2003, no evidence of water intrusion, solely the claim for mold. All the damages and the reason for vacating the apartment in 2003, mold related. In 2013, a claim for...
Did you skip September 2004, or did you say that was water?
No, wait, I was going to get back to that.
Okay.
I was going to say.
That was the time that the water came cascading down the circular steps, right?
Correct, in 2004. 6 months later, mold breaks out. That's when the Bakers vacate the apartment. That's when they discard all of their property. They don't do it as the result of water. They do it as the result of mold, which is a claim that Judge Nervo had dismissed.
Or was it moistness? I don't understand the distinction between moistness and water.
The water wait, I follow. Moisture, damp. Things are damp. All right? And the water is the water that intruded into the apartment, which was more of the negligence cause of action in the case. But if, as you're saying, that mold can come from moisture, the judge dismissed both from the case. And with the 2005 to 2008 issue, the entirety of the reason why the Bakers vacated was mold. I believe Ms. Baker's exact words at trial were mold erupted all over the apartment. They didn't leave because water came in in 2008. I believe they left for 2 weeks during that period of time. But the 3-year vacator that is the center of that time period was solely related to mold. The remediation was due to mold, and during that time they didn't come back because of the smell of mold. Mold is all over every single claim for damages in 2003, between 2005 and 2008, and in 2013. Once the judge dismissed claims for damages that are the result of mold, all of the damages came out of the case. This claim was...
Before your time runs out, do you want to address the interest issue?
Yes. Interest can be stopped by equitable considerations, and I would suggest to you that this case, that Judge Nervo understood this, and there's no reason to disturb the discretion that he used. I think, as you pointed out, there were numerous occasions. While there's evidence in the record of what the Bakers should have paid, there is no evidence that they actually paid it and did it in a timely fashion. At the time of trial, they were current on their maintenance. However, there are numerous times when they didn't. If the purpose of, and there's cases that say, the purpose of the interest is to provide the person with compensation for the advantage that the other party had for use of the money. I don't think there's any evidence in the record for the periods of time that the Bakers are claiming interest for, that there's no proof that the co-op had use of that money at the time. For the period of time between 2005 and 2008, they definitely didn't. That money's still in escrow. And it's fair to say, nobody can make use of money that's in escrow.
Thank you.
Good afternoon, Your Honors. Lawrence McGivney from the law firm of McGivney, Kluger, Clark, and Tosha. On behalf of the third-party defendant, respondent appellant, Penmark Realty Corporation. I have slightly different issues to argue because I am only a third-party defendant, but I would briefly say, with regard to the mold issue, in this instance, the mold could not get backdoored in as evidence because there was no experts who could testify as to an elevated, dangerous level of mold.
Okay, so let's assume the mold is out. What about the water?
Sure.
All of that
water
still reflects the water, right? The court
mold
gave damages for the water.
No, Your Honor, you can't get mold damages without an expert.
No, I
Bottom line
didn't, maybe you misheard me, I'm sorry. I said the court gave damages for the water.
No, Judge, you did not. The court gave damages for mold. You see, we'll use as an example, in 2003, that initial mold in the upper master bedroom, there was no evidence of water intrusion. There was none. There's mold on a wall. There's no source ever introduced or proven at the trial. No evidence brought in as to how did it get there. There is a gap in the causal link that plaintiffs failed to produce. Why did that happen? Because they took down the walls before an inspection could actually be done. So in absence of that evidence, we don't know why it's there. They can speculate. We think it came from outside in, but that's speculation. That is not evidence, and it's not in the case. That is why the court could not award damages for solely the mold. The only time the court can actually award damages for a real leak is the water that comes down the staircase, because there it is, the water coming in, and there's clear evidence of that.
Counsel, with respect to Penmark-specific issues,
yes, Your Honor.
You would argue that Penmark did all it could. It got some experts in to try to figure out what was going on with respect to the apartment, right? And that
Absolutely.
You did your job under the contract.
That's exactly right, Judge.
So therefore, you shouldn't be charged with any contribution to 40 East, correct?
That is correct, Your Honor.
You want to unpack that a little?
Certainly, Your Honor. My obligations are set forth in the terms of the management agreement. That's at 4219 in the record. It specifically says that our obligation is to bring in any export or incur costs for repairs above $2,500. Clearly, this exceeded $2,500. Mr. Marshall testified for the board at the time.
Part of that argument is that the other defendant, the co-op, had ultimate control over anything that would be done.
That's exactly where I'm getting to, Your Honor, is that it says specifically in the lease, that, not the lease, but the management agreement, that I have to bring this information to the board and they must decide. Mr. Marshall testified as a board member and indicated that, in fact, yes, this was operative and that we had no obligation other than bringing forth the recommendations. And we recommended 3 different engineers as well as contractors to perform these repairs. These were all licensed engineers who had, one gentleman had 50 years of experience, another 30, and another 20. We met our obligations under the terms of the management agreement, and that in absence of our ability to have ultimate control, we cannot be held liable because we met the obligations under the term of the contractual obligations. The only other thing I would touch on, Your Honor, is a little subsection, which is where Judge Nervo found that Penmark was liable for damages after it was no longer the property manager after 2009. The case law
Up to December 31st, 2009.
That is correct,
You're
Your
saying
Honor.
nothing after that.
Correct, Your
Because
Honor.
they were already out. And I think that Elliman's manager looked at everything and said that there were no issues.
That is correct. And in fact, there were repairs, proactive repairs made after we were there, replacing the roof, working on the northeast parapet wall, and so forth. And it's 3 years later when the issue arises after I'm no longer there. And for those reasons, on that sub-issue, it was wholly improper to hold Penmark responsible for damages that was sustained during that time period. Thank you, Your Honors.
Thank you.
Mr. Schultz for the corporation argues that there was no evidence of water after 2003. That's just not accurate.
Why don't you focus on where it is? Where is the water? He's saying there was lots of mold and there was no water pouring down the stairs. Was there a need for water to pour down the stairs? Where is it, if you would specify? Where
I will
is
tell
the
you that
water infiltration?
and I can give you a record site on each and every one of the
Okay,
items.
go ahead.
Page 916 of the record. In 2004, there was water here and there. In April of 2005, there was another leak in the electrical box. That's at page 1260. The following month, in May of 2005, and that's at pages 917 to 24 of the record, there was water intrusion. In fact, that was characterized, and I will find it for you, as major water intrusion. That's when the cause for much of the need to dispose of the items that were damaged by the water. And I have to point out, I mean, the court presumably had the opportunity to see the videos of the water pouring down the stairs.
They're not challenging where the water poured down the stairs. They're saying, yes, where the water poured down the stairs, okay. They're saying, but that was it. So are those all of the instances?
No.
Okay.
In July of 2003, this is at page 893 of the record, there was water damage in the ceiling of the baker's daughter's bedroom. In April of 2008, this is at pages 1139 and following, there was wet plaster peeling from the east wall in the kitchen. That's the wall away from the electrical box. You don't have wet peeling plaster unless you have water. There was water pouring down. Mrs. Baker testified in.
So these are your allegations of water. Why don't you continue with regard to the damages?
With regard to
The damages for that and your other points.
Yeah, well, I would say it's not simply the.
Why don't you address the Penmark issue? What's wrong if I say, well, what do you want from Penmark? You had ultimate.
I don't want anything from Penmark.
Yeah, right.
My claims were dismissed.
Right.
That's between them.
Yeah, right.
In terms of water, I mean, Stephen Marshall testified that the board was aware of water infiltration as early as July of 2003, and that the board was told of water perhaps 12 times over the ensuing decade and some. In 2008, when this is at page 947 and following of the record, when the redoubtable Mr. Cortazar was doing the repairs in the apartment, water rained down from the third bedroom den, which was on the first floor. The water ruined cabinets. That's at page 961. There was water infiltration creating a flooded area underneath the spiral staircase. Also at the exposed pipes at the east wall of the kitchen. That was page 962. In July of 2013, 10 years after the first event, there were water stains in the master bedroom, and there was testimony that the master bathroom felt like a sauna because of the amount of humidity. And there was also testimony about the removal of the water and how much there was. That's at page 980. And in terms of damage, there was testimony that in May of 2005, property had to be thrown out because it was waterlogged. The kitchen cabinets were destroyed by water. You only have to look at the videos of the events in September of 2004, when the fire lieutenant told the bakers that they better clear out, to see the amount of water that came down, and it's perfectly logical that that would result in damage to rugs, to floors, to furniture in the living room. And the amount of humidity was quite high. Continuing the water throughout the testimony of Michael Gurovich, who was our brick expert, he referred to, over months and years, conducting water tests on the walls to determine the amount of ambient humidity, and he testified that was high. If I can, I'd like to step back just for a minute to a couple of the items that are involved in our...
Your time has run.
I see that.
Yeah.
Thank you, Your Honors.
Thank you.
I just want to touch on 3 points in rebuttal. One.
Let me ask you about Penmark. Why should Penmark be liable to you when you had ultimate control over what was going to happen?
Penmark should be liable. The co-op relied on Penmark for everything with respect to the Baker's apartment. Whenever there was a complaint, the Bakers notified Penmark. Penmark was the one who hired and oversaw all the contractors. In the record, you see numerous letters and reports from the contractors. They are to Penmark. The co-op relied on Penmark as their managing agent to relied on their expertise. If there was something to be done, we relied on Penmark to do the right thing.
How much could Penmark spend without getting your approval?
But I would say, there's a reason why it's 50-50, in that the court found that we made the decisions, but it was all based on Penmark's recommendations. There was no decision.
Did you ever refuse to follow or decide not to follow Penmark's
Never.
suggestions?
With respect to the Baker's
You let me
apartment.
finish then.
Oh, I'm sorry.
Did you ever refuse to follow Penmark's recommendations?
No. Every recommendation they made, every suggestion they made was followed to the T.
Is there any reason why Penmark should be in after 2010?
No, and neither should the co-op. In 2013, Judge Nervo was quite clear. He acknowledged that the 2013 damages in its entirety were mold-related. It shouldn't be in at all. There is also another argument to the Baker's pleadings allege that all of their damages flowed from Penmark's action. There's also another reason why those 2013 damages, in addition to being for mold, they're outside the scope of the pleadings.
So you're saying that all of the damages, all of them, even the ones after 2010, were mold-related and not water-related?
The 2010 damages, all that there is there's the kitchen, of which there are other issues with respect to the kitchen, and the 2013 to 2015 damages are exclusively related to mold. In fact, that was the judge's finding in the court below. He acknowledged 2013 to 2015, the reason why the second floor was sealed off, the entirety of that was mold-related.
Thank you.
All right, thank you very much.
I would say, Your Honors, that every time counsel mentioned the water damages, and you should look at the videos and pictures, it's all talking about the same staircase. That's where he's talking about the water, and we don't disagree that that's where a water intrusion happened, and there's proof at trial that there was a water intrusion. And everything else is about mold, which the judge ruled was out of the case. With regard to Penmark and its obligations, it is the agreement that decides what our liability is and our obligations. Page 4220 of your record, key is where it says that any decision made by Penmark over $2,500 shall be made only with the approval of the owner. The owner doesn't get to sit back and then say, well, I'm not responsible for anything. Because
were there instances where Penmark made recommendations that the owner didn't follow?
I apologize, Your Honor, I could not.
I said, were there instances where Penmark made recommendations that the owner didn't follow?
No, Your Honor.
So anything Penmark suggested, the owner did.
When we made suggestions, Your Honor, we didn't make specific suggestions as to repairs, because that's not our expertise or our duty. We recommended that they hire
Yes, no, that's what I'm
engineers.
talking
Those
about. You recommended that they hire experts, or you hired the experts came in and made recommendations. Did they ever not follow expert recommendations?
No, Your Honor, they followed the recommendations of experts who were referred or recommended by Penmark, but Penmark is not responsible for the recommendations made by the engineers themselves, Your Honor. That is an independent responsibility that the owners maintain the duty to determine whether they want to follow or not. My job isn't to tell them how to repair the walls or do inspections. It's to get them competent people to do that, which we did. Thank you, Your Honor.
Thank you.
Might I just say, Your Honors, that after 2 years, it is a pleasure to be back in court. Thank you.
Well, it's nice to have you back. Echoed from all. Thank you. We're happy to have you here. Chen versus Ramona Kevezel collection.
Good morning, Your Honor. May it please the court.
Good afternoon.
Sorry.
But I can imagine how you would like it to be morning, I guess. Go ahead.
My mistake. Good afternoon, and may it please the court. In a case of first impression, each of respondents fall beyond New York's Freelance Isn't Free Act statutory definition of freelance worker as any natural person or organization composed of no more than one natural person, whether or not incorporated or employing a trade name. Indeed, Respondent Chen's own contract, invoices, and affidavit irrefutably established a bargain for quartet of no less than 4 individuals contracted to render services.
How about Kozlovska? Was there a period of time where she was not represented by her modeling agency, but rather was just freelancing on her own?
Not to my knowledge, Your Honor. The claim at all times for the specific transaction was through the agency, through the contract, given by the agency, and from the invoice from the agency.
The invoices only covered certain periods of time. I think one time in April, one time in September, but she's making claims for periods of time outside of that. So why wouldn't she be a freelance agent at that point, during those outside of the invoice times?
The invoices were produced by respondents. We said simply she falls outside for the specific transaction. They said, laying our proof bare, these are the invoices we have. Where they're getting that, I can't tell you, Your Honor.
Did they show any other invoices other than the ones for September and April?
Those are the only ones proffered by respondents, Your Honor.
Did she work outside of that time, September and April, for defendant?
Specifically for our client, she was hired for one shoot under this exact claim and under her complaint with the New York Office of Labor Policy and Standards. It only references that one claim.
Are you saying that she did not work from 2017 to December 2019 for your company?
I have no proof of that, Your Honor. I just don't know. The record wasn't developed enough.
But the complaint makes a claim, mentions a period, I shouldn't say makes a claim, but it mentions that this is for the period ending in December of 2019. Am I correct? That's what the complaint says as to Kozlovska.
Right. And on our dismissal motion, we said you fall outside the Freelance Isn't Free statutory definition, and in opposition, they were only able to proffer that one invoice and that one agreement for the one shoot in Toronto.
That's the only opposition they had, which was under the VNY name. Is that correct?
Correct, Your Honor.
Which, when the claim had been filed with the Office of Labor and Policy Standards, said that there's more than one person involved, taking it outside of the act.
Exactly, Your Honor. I was actually just going to get to that. That's record page 141 at question 5, where both Kozlowska and at record page 127, each of Kozlowska and
Maybe you
Chen.
could just clarify for me. Are you saying that the sections, the complaint said 2017 to 2019?
Right.
And are you, and the evidence they gave by way of these invoices was for April 10th through the 15th of 2019 and September 23rd through the 25th of 2019? Is that right?
Correct, Your Honor. I'm
Those
sorry.
were the periods that she was claiming she was represented by VNY, right?
Correct, Your Honor.
So those periods would be taken outside of the FIFA.
In addition to that, Your Honor, there was also the Office of Labor Policy Standards and Complaint that only lists, to my knowledge, the specific, the agreement underlying the Office of Labor Policy Standards and Complaint, the OLPS form. The only thing that was proffered was the one agreement and the one shoot date.
Does she have a claim for the period of September 26th, 2019 to December 31st, 2019?
I don't know, Your Honor. That wasn't in any of the opposition papers on any of the dispositive motions we made. We said she simply falls outside no matter what. They never said.
So you mean when you moved to dismiss, the only thing Kozlowska came back with is that I was employed by you during April 10th to April 15th and September 23rd to September 25th, 2019. That's the only thing she made a claim for.
That's the only thing she showed in opposition to dismissal, Your Honor. I reserve the remainder of my time for rebuttal.
Thank you.
Unless the court has any other questions right now.
No.
Good afternoon. May it please the court. James M. Murphy for plaintiffs, respondents, appellants. The complaint alleged that Ms. Kozlowska was employed, engaged, in whatever term you may refer to it as, by Ramona Kevezel as a model over this 2-year period. Defendants made a 3211 motion where plaintiffs are not required to prove a case, are not required to come forward with documentation or evidence of their claim, where the allegations in the complaint are deemed to be true.
But you made a complaint to the Office of Labor and Policy Standards, didn't you?
Yes, which is not a prerequisite to filing an action. So the complaint that was made there, the documentation that she was in possession of at that time was limited to the invoices that were attached.
The only documents in front of the court have Kozlowska working through VNY, right?
Correct, yes.
And she's already said to the Office of Policy and Labor Standards that she's not an individual working, but that was more than one person working, which would take you outside of...
Oh, we would vehemently dispute that. The specific language of the administrative code says that a freelance worker is any natural person or organization composed of no more than one natural person performing services. She is a natural person. She was performing services.
But she checked the box, I mean, with respect to the OLPS claim form, she checked the box that she was a group of 2 or more. So is that documentary evidence that undermines the complaint fatally?
Oh, absolutely not. There were other people that were performing the same work as she was. She was not part of an organization, a corporation, a subcontractor that consisted of multiple different people subcontracting for these services.
So if she's filing a claim for herself, and the statute seems to require that, does it not, how does she check a box for 2 or more?
Oh, there were other people who were also acting as models. She's filing a complaint for herself. She wasn't filing a complaint on behalf of anyone else. They're asking her, did you alone do this work, or were there other people that were doing this work? And yes, there were other people that were doing this work, but the definition in the statute does not require.
But isn't the whole point of the statute if you're part of a group, so you don't need this special protection in terms of what your attorney's fees might be, et cetera?
That doesn't appear anywhere in the statute. The statute says that individuals or single-person entity corporations have these rights to pursue these remedies. It doesn't mean that if there's a photographer and a lighting person and a model.
So you're saying if the organization is a single corporation organization, it could have 1,000 people working for it, and any one of those people could make a claim under FIFA?
If those people were employees of that corporation, then it would no longer be a single-person corporation.
Isn't she an employee of VNY during the period that she's under contract
There's no
with them?
evidence that she's an employee of anyone.
Isn't she under contract with them?
She's under contract with them. There is no independent contractor agreement. There's no employment agreement, anything like that, provided by the defendants or provided by the plaintiffs.
So then what's her relationship with VNY?
If VNY is a modeling agency that the defendants allege has a contract with Ramona Kevezel, which wasn't produced at any point, to refer models to Ramona Kevezel. So she's a model that was referred
It's
by
her
this
agent, in other words. It's not her employer. That's what you're saying.
Correct, yes.
That's interesting.
And so her job is to show up and be a model. She's not employed, she's referred by the agency. In the same way, Chen is an individual. He had other people that were providing services, but under the definition included in the statute, a single-person corporation, such as Chen, can bring a Freelancers and Free Act claim, specifically because these types of workers, these types of individuals, generally have no other recourse. If it's a corporation that has shareholders, if it's a closely held or a public corporation, they can go ahead and file a lawsuit for breach of contract. But individuals, such as Chen, such as the other plaintiffs here, don't have that ability to go out and say, you didn't pay us $3,000 that was outstanding on the invoice. We need to file hire attorneys to file a claim over that. That's the purpose of having the Freelancers and Free Act here. The fact that other individuals were also working, there may have been 6 models instead of just 1 model at a time. There's no basis whatsoever in the text of the statute that would pull that out of the protections provided by the Freelancers and Free Act.
Thank you.
Just a few quick points. The definition of the freelance freelance worker is any natural person or any organization composed of no more than one natural person. Clearly, Chen, by having at least 4 employees plus the entity of Chen Inc., is an organization
Right, but the issue is really with Koslova, right? Is she employed by VNY? Are they just her agent? Is there a difference when it comes to FIFA? Is she a single individual? How do we characterize her?
Well, we would submit, based upon this, based upon the OLPS complaint form, in addition to the acting as a group of 2 or more, I would point the court to question number 8, where if it says, was there a written agreement, if there was no written agreement, how did the hiring party communicate the payment amount for the work? And she checks herself, under penalties of perjury, through a third party. Presumably she's speaking about her agent. You could be a freelance model without an agent. You could do your own bookings. You can do your own invoicing. When you associate with a modeling agency, I would submit that under the Freelancers and Free Act, you are beyond this definition, the statutory definition of freelance worker, as you can't perform the services in the absence of both your agent and your agency, meaning there's at least 3 individuals or entities that join together to do the work. I'm sorry.
Can we pivot for a second to the sanctions? You're appealing those, but are they appealable?
Sure, Your Honor.
Weren't they made sua sponte by the judge in response to what happened in front of her, for the most part? And so therefore, you'd have to move to vacate and then appeal from that?
Well, each of the sanctions were levied under each of the motion sequence numbers 1 through 5 orders.
Yeah.
So we filed notices of appeal on each of motion sequences number 1 through 5 orders. And secondly, Your Honor, I would say...
But was there ever a notice of motion seeking sanctions? In other
Never.
words, so it was about motions about other topics. And then during the course of that, there were things that the judge found to be sanctionable, right?
While we disagree with those findings, we moved to vacate motion sequence 5, which said, in addition to all the prior sanctions, we sanction you additionally for whatever reasons. But we had moved to vacate each of the default and all the orders
But you
before.
moved to vacate the sanctions.
We moved to vacate the orders, Your Honor.
The orders, not the sanctions.
Well, the sanctions were in the orders, so presumably we were moving to vacate everything about it.
Thank you.
There's a way of looking at Chen and Kozlowski differently?
Is there a way?
Or do they rise or fall in the same way?
Your Honor, I started my career as basically a freelance worker, a solo attorney with my own shingle, no secretary, no nothing. That's neither Chen nor Kozlowska. Chen has at least 4 individuals working for him in his corporate entity to provide the services that people contract for. Kozlowska would never know my client if not for her agent. So at the very least, you have the agent, the agency, and Kozlowska coming together to provide the service.
So that would be the case even if it was a friend of Kozlowska who referred her to you? That would still be, that would be 2 people, and so therefore not under the realm of the statute?
Well, Your Honor, when my friends do favors for me, they don't charge commission. Meaning, VNY and her individual agent got a fee for the placement, and that's record page 190, I believe, is the invoice from VNY and from the model booking agreement.
Thank
Actually,
you.
sorry,
Oh,
sorry, record 99 and record 190 are the agreement and invoice at issue for Kozlowska. And if there's no other questions,
I've got one other question, if you don't mind, Judge Renwick.
Okay.
You notarized the answer on, I couldn't quite make out the date. Was it April 21st or April 27th?
I believe it was April 27th, Your Honor.
I see. And you didn't e-file until May 5th, right?
Correct, Your Honor. It was,
Why?
I would submit law office failure. By the time I scanned it and,
I mean, by the 27th was a law office failure too, right? Because it was due on the 6th of April, is that right?
I believe the notice of entry was March 17th, so 30 days after the order was entered would be April 17th. As my client put in her affidavit in the motion to vacate, she's in Toronto. She said there was a shortage of American notaries and she had trouble. So by the time, she had business in New York, she swung by my office, I notarized it, I must have scanned it, went on with the day, and, thereafter, when I was preparing to appear at the preliminary conference, reviewing the docket, I had noticed it wasn't there, I uploaded it, and then went to the conference, and everything unfolded from there.
Any further questions? Thank you.
Thank you, Your Honor. Take care.
We still have 2 minutes. We still, as a cross appeal.
Sorry.
Okay.
Okay, so very briefly, the court dismissed Ms. Kozlova because she contracted with Ramona Kevezel through the employment agency, or through the modeling agency, even though there was no copy of a contract between Ramona Kevezel and the modeling agency before the court. The court did not dismiss Chen's claim because there was a direct contract between Chen's DBA, his sole proprietorship, and Ramona Kevezel. So it's not necessary that both claims rise or fall together. The court below didn't find that they rose or fell together. So, we obviously have cross-appealed the dismissal of her individual claims. We have not cross-appealed the dismissal of his individual claims because his claims are continuing on through the
It's a
court.
claim against his corporate entity.
Claim by his corporate entity against Ramona Kevezel, which is allowed under the Freelancers and Free Act. Specifically, that provision about no more than one person allows sole proprietorships to file these claims, whereas it may not allow partnerships or closely held corporations, but sole proprietorships, such as Joseph Chen Inc., can bring these claims under the Freelancers and Free Act. That's what that single person definition means in the administrative code. It's a little difficult to provide any kind of specific evidence on that because this is the first case where this issue has arisen. There's only been one lower court case on the Freelancers and Free Act, which specifically said that a model did not bring a case against the correct defendant because she brought in a claim against her agency and not against the corporation that was engaging her services as a model. There is no appellate law on this new
We take the point, counsel.
case. So
Does the record before us show how much the sanctions were quantified as? I mean, I don't think, is that in our record?
there was an order for the attorney's fees, which I believe was $16,400, which was the amount of the bond that was issued by Ramona Kevezel. Strangely, even though they weren't actually sanctioned, it was counsel personally that was sanctioned, but whatever reason, Ramona Kevezel posted the bond. So we do also argue that there is no standing here for Ramona Kevezel to appeal this, since no notice of appeal was filed by the individual who was sanctioned. Ramona Kevezel does not have to pay these sanctions and isn't harmed in any way by these orders.
Thank you.
Thank you.
Thank you both.
I can allow these court orders to come